It's the Law.
Welcome to It's the Law, a program produced and presented by the Guyana Association of Women Lawyers. On this program, a member of the association gives us an in-depth look at Guyana's laws. Today's topic is police powers of questioning, as we continue the series Police Powers under the Police Act. Here now is Tavera Franklin.
This information provided does not and is not intended to constitute legal advice, and there has been no attorney-client relationship formed in the use of this information. Please seek legal advice from an attorney at law for your individual legal needs. Today's topic is police powers of questioning, in which we will discuss the right to silence, the rules governing police questioning, the voluntary nature of statements, and tips to remember when being questioned by police officers. In many cases, you will want to help the police when they ask you questions, as they need public cooperation to do their job properly. But it is important that you know when you are not legally obligated to cooperate. The right to silence. In general, you do not have to answer police questions, whether they're informal or part of an official inquiry. But failing to answer certain questions related to traffic offenses is an offense. You must answer police questions about illegal drugs, and refusing to answer questions, particularly when the police have the power to stop and search you, may cause the police to become suspicious and to arrest you, even though the suspicion may be unfounded. If you do choose to speak, it might be better to say, "I do not want to say anything until I have seen my lawyer." Although you may feel it would be quicker and easier to clear a matter up by answering police questions, it is better not to do so until you have had legal advice. However, if legal assistance is not readily available to you, and you are in a position to make a statement that will prove your innocence, it may be better to do so or to otherwise cooperate with the police. What are the rules governing police questioning? A police officer's conduct during questioning is governed by what is called the judge's rules. These are not legally binding, and even where they are not obeyed, a magistrate or a judge can allow your statement to be used as evidence once he believes it was made voluntarily. This gives the police little incentive to follow the rules. The main rules are as follows. A police officer can question you whether or not you are suspected of an offense if the officer believes they can get useful information from you. They can question you without arresting you, provided that you have not been charged with an offense or informed that you may be prosecuted for it. Police officers must give a first caution. As soon as the officer has reasonable grounds for suspecting that you have committed the offense, they must caution you by stating that you are not obliged to say anything unless you wish to do so, but what you say may be put in writing and used as evidence. Police officers must give a second caution. This caution should be given when you are charged or told that you may be prosecuted for an offense. You should be asked if you wish to say anything and told that you need say nothing. But whatever you do say may be taken down in writing and used as evidence. As a general rule, no questions should be put at this stage unless their purpose is to prevent harm being done to other people, or to make clear the meaning of the answers or statements already made. If such questions are to be asked, you should be given a third caution. In terms of rules concerning giving statements, if you are questioned or decide to make a statement after being cautioned, a record should be kept of the time and place of the questioning, who was present, and of what refreshments were given. Alcohol must never be given. Questions and answers should be recorded in full. The record should be signed by you, or if you refuse, by the officer questioning you. Answers can be used as evidence, whether or not you sign the record. There is no such thing as an off-the-record statement. Any statement you make after being cautioned should be written on the proper form. Police officers should only use their notebooks when there are no forms available. If you make a written statement, you must do so without prompting and in your own words. Or you can dictate it to the police officer and you will then be asked to sign it. If you refuse, again, the officer must sign. If an officer writes down your statement, the officer should write it in your words and not translate them into police talk or any other talk. You must not be led to believe that any statement you make can only be used against you. If you are innocent, this may prevent you from making a statement which might help clear you of the charge. You should be told what rights and facilities are available to you. Notices stating what your rights are should be clearly displayed in the police station and drawn to your attention. Reasonable arrangements should be made for your comfort and refreshment. Whenever possible, you and the officer questioning you should be seated. Rules when questioning children. As far as possible, children under the age of 17, whether they are suspected of a crime or merely being questioned as witnesses, should only be interviewed in the presence of a parent or guardian. If these are not available, the child may be interviewed in the presence of someone who is not a police officer and who is of the same sex of the child. A child should not be arrested or questioned at school if this can be possibly avoided. However, if it is essential to do so, it should be done only in the presence of the head teacher or his nominee or with his or her consent. The voluntary nature of statements. Any statement made by you should not be used in evidence unless the court is convinced that they were made voluntarily. The prosecution must prove that this is so. If inducements or threats are made to you while you are being questioned, your statement will not be considered voluntary. An example of an inducement is a police officer stating, "We can make it easier for you if you confess." An example of a threat would be a police officer stating, "We won't give you bail until you make that statement." But remember that even if the judge's rules were not followed, a magistrate or judge can still decide that your statement was made voluntarily. Here are some key tips to remember when being questioned by police officers. Never rely on a police suggestion that a confession will make things easier for you. Try to ignore all threats and inducements to make a statement if you don't want to make a confession if you are innocent, or to sign a statement that you have not given. If the police questions you at your workplace, you should get in touch with the local representative of your trade union or professional organization at once. If the offense has nothing to do with your place of work, you should refuse to discuss it in the presence of your employer. Even if the offense is concerned with your place of work, remember that you do not have to say anything. This is the end of this episode on police powers of questioning.
This has brought us to the end of the series on police powers under the Police Act on It's the Law. You have been listening to It's the Law, a program produced and presented by the Guyana Association of Women's Lawyers. The contents of this program are not to be taken instead of legal advice.